From supplementary list, item number 1.
This is
Mr. Khan,
sorry, Lordship.
Mr. Khan, now once you organize yourself, bring us to the investigation reports pertaining to circumstances and causes of death, and bring us to, there's some evidence which has been taken, to any evidence on that aspect before you come to the charge sheet. If we are happy that it was a case of suicide, then we'll not pursue it anymore.
Highly grateful.
Because as to what circumstances drove him to suicide or abatement to suicide is something which personally I feel can never be proved. Because abatement to suicide is a state of mind. You know, when you ask someone, you put a gun to someone and tell him that shoot yourself, and that person doesn't realize, shoots himself, that doesn't amount to suicide, that amounts to murder.
Absolutely correct.
It amounts to murder.
Very difficult to prove.
Very difficult to prove abatement, because what triggers off that psychological condition in you where you want to, take your own life is something, and for some time it was gone. For some time when suicide was decriminalized, even abatement was gone.
Gone.
But then
There has been restored.
it was restored back.
Except for 307 abatement.
If you have anything to say, despite you not having any locus, we'll treat you as a friend of court, and we'll, if there is anything suspicious, you can point out. But from whatever we have seen, the situation was very bad. The mafia was there, everything was there. But at the end of the day, if it was a case of suicide, and we do not have any evidence of threat from whatever little that I have seen, then yes.
Lordship, if the Lordship has the Supreme Court order with you, Lordship.
Yes.
Lordship, I can give an extra copy.
No, it should be in the record.
I'll give it, Lordship.
Why is it not in the order file? It should be part of the order file. Yes.
Lordship, if you can come to page 2, just the relevant part. If you start from the bottom paragraph, page 2.
Yes, exactly what we are saying.
Lordship.
Exactly what we are saying.
So last paragraph of this, the direction is at page 3, Lordship, the last paragraph.
Yes, it is. Yes.
So, Lordship, the order was set aside and the matter was remanded back to the High Court to decide and dispose of the writ petition afresh.
Yes. So show us what we are asking.
So, Your Lordship,
Mr. Khan, don't get into that area, because the moment you do, and we find reluctance on the part of the state, immediately we will suspect foul play.
Lordship, I just wanted
So
to,
show us what we want to see.
first thing, Your Lordship, just wanted to bring in that the charge sheet that was filed. Honorable Supreme Court has not touched that, neither it has said anything. What it said was under 173(8), there could be further investigation. So our
Let
Lordship,
us see the investigation on the aspect of death,
on the aspect of
and let us see the evidence.
Lordship will take Lordship first to the case diary. We are given the copy of the case diary.
Yes.
Lordship has got it. This is it. The handwritten copy of the case diary, not the charge sheet, the case diary part.
This is the charge sheet, is it not?
But Lordship, I'll be relying first because the statement on the case diary.
Because this is findings and charge sheet.
Lordship, yes.
The charge sheet is there. So whatever is there in the charge sheet, you point out what was relevant.
Lordship, basically the charge sheet goes like this. On 24th January 2015.
No, don't read the entirety. Just
So, Lordship, I wanted to come, Lordship, we just kindly have it, this case diary. I just come to the relevant evidence.
yes.
Lordship, we'll just come to page 12. Page 12. And the type copy is at page 107, Your Lordship. But the statement of P. Champliang, the first person who saw.
107.
107.
You have these papers?
My lord, I do not have it. You will not serve with the copy, man.
No, well, give him the paper. Give him these papers. Give him these papers. Do you have a copy? Just give it to him. Let him follow. Both the charge sheet and the case diary.
No, that is not it. One copy I have, but it is different. It will not match.
Yeah.
Thank you.
Lordship will be on. So, Lordship will take your Lordship to 107. The type copy at Lordship, page 108, the last paragraph is relevant for the present purpose.
Where are the photographs? Referred to at page 109.
Lordship,
The middle paragraph at page 109, about 5 lines from the top.
Lordship, we'll have to come to
Chief
the...
Hostin said he had a mobile and I was directed to take pictures of the room, especially capture the IC who was lying on the floor.
Lordship, we just come to page 19 of the chart sheet. This is the case diary, Lordship. Chart sheet. The pagination is done from below, Lordship.
Yes, usually that way.
Page 19. 19 onwards.
21. Page number 21.
Graphic is at page 21. 21, 22.
Postmortem report.
Now, should we come to page 5, same chart sheet? Lordship, there is also a second postmortem report. There is a second postmortem report. There was a conflict. I just clarify, Lordship.
Yes, where is that?
Lordship will just come to page phase.
Oh, the second is postmortem at Dongpo Civil Hospital.
Lordship, yes.
We've seen that.
Lordship, no. First was done by a community health center, Patharkhama, page 3. So there is not postmortem. That was. She had made a statement, Lordship, which said entry wound was from back of the head, while the exit wound was from forehead. So based on that, then first postmortem was done at Nagpur Civil Hospital, Lordship. Now, because there was two opinions, so we sought for a second postmortem after the body was exhumed. And that, Your Lordship, we find at page 8.
Where is the petition? Where is the petition? Affidavits, documents, order sheet.
No, Lordship, these are three doctors' statement before the court. Pathar Kama, the first postmortem doctor, and the second doctor. The first CMC Pathar Kama doctor, Lordship, she is PW2, which is at page 3.
But this is the same person who had said that entry from back and exit from behind. Is this the same person who had said that?
The entry from back was the same person. Yes, Lordship. Yes, Lordship is correct. Same person, Lordship. Lordship, you can just have it in the last part of the in chief.
No. What did he say but that he had said something different earlier?
No, she said the same thing.
No.
Then
He
that,
said over here, from the examination of the wounds and the subsequent findings, I am in the opinion that forehead wound was an entry and back of the head was an exit wound of the firearm bullet.
Lordship is reading which page, Lordship, please?
This is Danny Morris moment.
No, Lordship, no. That Danny Morris moment is the first postmortem.
First postmortem.
Lordship, we'll come to page 3 first, Lordship. Page 3, please.
Page?
Page 3 of the same page.
Three is who?
3 is the CM Patrakama doctor. First doctor, she had entry was from front and we'll just come to Worship, she's the doctor who said entry wound from the back. Entry wound from the back.
Was any person charged?
Lordship.
Was any person charged under the charge sheet?
Yes.
Where is that? Conclusion?
Lordship, you just, the copy that I gave it to you.
Yes.
There's a first page, Lordship. First page. First page.
Oh, just now.
Lordship. Just first page. Lordship.
All amendment.
All of it.
Yes, we're closing it.
But if I can point out few things, my lord. My lord has already seen in the writ petition, my lord, I have enclosed the report from the doctor, wherein the disease was immediately taken.
Yes.
That doctor,
Please. Just the only thing in the writ petition, we read the entirety of it, which shows any anomaly, was the description of the wound. No other anomaly.
yes,
Now, that doctor may have changed his version, and we are alive to. But the fact is that that doctor is at a community health center.
yes,
He is no specialist, and it says testimony that the patient was alive when he was brought, and he was referred to Guwahati. At that point of time, the doctor and everybody else, their primary concern is how to save the life.
yes,
And in course of inspecting what has happened, he gave an opinion. He also said that that was his first case of any bullet injury.
yes,
So therefore, on his own saying, there is no, he has no experience. And thereafter, there have been two, and there's scientifically indicated that generally, if you are aware of ballistic reports, the entry hole is smaller than the exit hole
yes, ma'am.
because it expands. As it travels, it expands after making first, contact. So that is consistent. That is consistent in both the things. The entry hole is smaller, that is, the exit hole is bigger.
My lord, here totally opposite, my lord. If my lord will see the postmortem report, it says the entry wound is bigger and the exit wound is smaller, my lord.
Let us see the
My
postmortem.
lord, in the document which is provided, my lord, the postmortem report is not here. However, my lord, I have a copy of the postmortem report.
No, we have it over here. Come to page 6 of the charge sheet. Postmortem at Nagpur Civil Hospital. Forehead wound, if you see number 6, stop. Forehead wound is circular in shape and measuring 1.5 and 0.9. Length we are not concerned with. We are concerned with the breadth. We are concerned with the shape. Is circular in shape. See the next one. Back wound is irregular. Measures 2.5 centimeter by 2.3 centimeter. So therefore that is consistent. Now let us go to the other second postmortem.
Page 8.
Page?
8.
Yes, second postmortem. If you see at page 9, underlined, the report indicated significantly that the entry wound is on the frontal region situated so and so and situated. So that was also corroborated. And this was conducted at Negrams.
At the cemetery, Your Lordship. At the cemetery from where the body was exhumed.
Yes.
It was on the
Yes,
spot.
by Negram doctors.
Yes, Your
by
Lordship.
Negram doctors. That is one. The second, which the mother says in the petition, is that he was a right-handed person. Why would he shoot with his left hand? Now, pulling a trigger is not so much of a difficulty with the left hand, even if you're completely right-handed. For someone like me, my left hand is almost useless. But pulling a trigger with the left hand is no big deal. We have whatever we have. It was unfortunate. There is no doubt that there must have been some other circumstance, something like pressure being put on him to release. But it wasn't as if he was killed by anybody else. Yes, he may have been driven to suicide, but it does not appear that he may have been killed by anybody else. And that is what our concern is. Driven to suicide,
My Lord, if I
then there's
can,
hardly, even if we have a further investigation, 306 will never be made out.
even the, my Lord, at the time of seizure of the weapon which was claimed to be used for the, committing the suicide, my Lord. At the time of seizure, my Lord, they should have written down the serial number of the gun. Whereas in this case, my Lord, 2 guns were seized, my Lord. 2 guns, one belonging to the gunman of Deputy SP Crime. Whereas why that gun was seized, that is the submachine gun, my Lord, that nowhere, the report nowhere says anything.
We are not convinced. At the end of the day, it's a subjective satisfaction. We are very remorseful that a life was taken away in such circumstances. We are concerned as the mother was, but on the basis of the material, the petition was disposed of by an order, judgment and order of March 22, 2016, declining the principal prayer in the petition for a reinvestigation into the circumstances leading to the death of a police official in Patarkama. Paragraph. The petitioner was the mother of the deceased. Full stop. The grievance of the petitioner was that the procedure under section 174 of the Code of Criminal Procedure 1973 had not been followed in course of the investigation, and that there was an attempt by the investigating agency to suppress the real facts and give the incident a color of suicide. Paragraph. There were 3 important allegations in the petition filed by the mother, who, unfortunately, has died since Full stop. The mother pointed out an anomaly that the doctor who had treated the deceased when he was still alive and taken to the Patarkama Community Health Center indicated that the gunshot wound that the then patient had suffered was from behind his head. Full stop. Such opinion revealed that the gunshot that the then patient had been shot on the back of his head and the bullet exited the cranium from the left part of the forehead. Full stop. However, as the petitioner duly pointed out, the postmortem conducted at the civil hospital in Nongpo on the next day, after the petitioner's son had expired, indicated that the gunshot wound was suffered on the left forehead and the bullet entered the skull from such parts and exited from slightly off the middle of the back of the head. Slightly off, that is double F. Full stop. Right. The second anomaly that the petitioning mother pointed out was that her son was right-handed and there could not have been any good reason for him to either commit suicide or, even if he did, to use his left hand to pull the trigger. Full stop. The third aspect pointed out was that the deceased police official may have earned the wrath of the mafia which is involved in this state, with connections to the most influential and the powerful, and dealing with illegally mined coal. Full stop. There is no dispute that about 32 trucks laden with coal, almost invariably illegally mined, had been stopped at Patarkama, at the Patarkama outpost on January 24, 2015. Full stop. The incident occurred slightly before 9 p.m. when two other junior police personnel in neighboring quarters, in neighboring lodgings, said they heard an explosion and first thought it may have been a firecracker, but later on hearing a moaning sound, comma, they followed the sound and they followed the sound which took them to the quarters of the in charge at the outpost and found such in charge lying in a pool of blood in his bedroom, with the front door to the quarters and the bedroom door open. Full stop. Paragraph. The charge sheet in this case was filed on October 10, 2015 in Nongpo PS case number 28-1-15 under section 302 IPC. Full stop. Charges were pressed against 5 persons under section 306 of the Penal Code, 1860. Full stop. Paragraph. At the time that the writ petition was taken up for final disposal, comma, the relevant bench noted that the investigation had been concluded full stop. The manner in which the relevant order of March 22, 2016 is worded gives an impression that the relevant bench of this court perceived that since the investigation had already been completed, comma, it was a fait accompli, and the court could not do anything further. Full stop. Paragraph. Agreed by the failure of the High Court to order further investigation or re-investigation or a de novo investigation as had been sought by the petitioner, comma, such petitioner carried a petition for special leave to appeal to the Supreme Court, being SLP bracket C number 15461 of 2023. Full stop. The relevant petition was disposed of by the Supreme Court by a recent order of May 8, 2023. Full stop. By such order, comma, the matter was remitted to this court, open court, to decide and dispose of the writ petition afresh in accordance with law and its own merits, and taking into consideration the observations made by this court in the case of Sushila Devi, in italics, bracket supra, ... close quote. Paragraph. Earlier in the Supreme Court order, there is reference to the case of Sushila Devi reported at 2014-1 SCC 269 and an observation that while disposing of this the writ petition, this court had, open quote, misapplied and or mis-construed the said decision, full stop, close quote. According to the order of May 2, or according to the order of May 8, 2023, in the case of Sushila Devi, the investigation by the Central Bureau of Investigation had already been completed, and it was in such circumstances that the court observed that the monitoring of the matter any further was not warranted. Full stop. Paragraph. The Supreme Court then went on to notice a judgment rendered in Criminal Appeal number 13 of 2023, bracket, Anand Thanur Karmes versus the State of Maharashtra, and quoted paragraph 11 which referred to two other previous judgments reported at 2016 4 SCC 160, bracket, Dharampal versus State of Haryana. No, it will be Dharampal versus State of Haryana. And 2013 15 SCC 578, Bharati Tamang versus Union of India. Full stop. Paragraph. In essence, comma, what the order dated May 8, 2023 observed was that a constitutional court, when in receipt of a petition complaining of irregular or insufficient or faulty investigation, comma, the mere fact that the investigation had been completed or that a charge sheet had been filed or that a final report had been presented under section 173(8) of the code would not deter the court into looking at the anomalies and directing further investigation or reinvestigation or de novo investigation. Full stop. Paragraph. As aforesaid, comma, the Supreme Court perceived that the order of this court of March 22, 2016, disposing of the writ petition by, comma, in effect, comma, declining the prayers therein, gave the impression that merely because the investigation had been concluded The High Court was of the view that it could do nothing else in the matter. Paragraph. It is in such circumstances that the nature of the investigation, the anomaly is indicated by the petitioner, and the circumstances leading to the death of the relevant official have been gone into in course of the present proceedings. Full stop. Paragraph. Both the case diary and the detailed charge sheet, comma, together with photograph appended thereto, comma, were called for. Full stop. During this period, the further conduct of the trial was injuncted, comma, so that it could be ascertained whether, so that it was first ascertained whether the investigation carried on or the report filed thereupon had to be disregarded, or whether any further or fresh investigation was called for. Paragraph. It is in such light that the matter has been assessed. Stop. Two junior police personnel who were cooking at their lodgings adjacent to the quarters of the in charge of the Patharkama outpost were the first to reach the spot, and it appears from their statements, independent statements, that they heard the sound of an explosion and their first impression was that it must have been a firecracker. Full stop. They later heard a continuing groan and followed the sound to the quarters of the in charge will always be hyphenated, and entered through the open door of the quarters and into the open bedroom to find the officer lying in a pool of blood with his face down on the left side. Full stop. Paragraph. Such police officials recounted that they did not touch anything but found that the left hand clutched a firearm. Full stop. There were senior officials, police officials nearby, comma, including a person from the Riboy, who was called, and comma, thereafter, comma, since they found the police officer, since they found the relevant officer to still be alive, comma, after taking photographs on their mobile phone, comma, they quickly took him to the nearest medical facility, which was the Patharkama Community Health Center. Paragraph. There is no doubt that the doctor who examined the patient observed that the gunshot wound suffered appeared to have been a shot from the back of the head with the bullet exiting the forehead. Full stop. However, it must be kept in mind that the person was still alive, and the primary aim of the medical personnel would then have been to resuscitate him and treat the injuries he suffered, rather than concentrate in any great detail as to how the injury may have occurred. Full stop. At any rate, since the relevant doctor found the patient to still be alive and showing feeble signs of life, since the facilities at the relevant CHC were inadequate, the patient was referred to GNRC in Guwahati, where he was taken and where the official apparently died. Full stop. The relevant doctor at the Patarkama CHC was examined in course of the trial, and he repeated that in his view, on the basis of his observation at the relevant time, he thought that the person had suffered a gunshot injury on the back of his head with the bullet exiting the frontal part of the cranium. Full stop. The official also admitted that this was the first time that he had treated a bullet or a gunshot injury. Full stop. Paragraph. The initial a postmortem on the body of the deceased police officer was conducted at the Longpur Civil Hospital. Full stop. The summary of the observations and the findings have been indicated in the charge sheet filed in the matter. Full stop. It appears that the doctor who conducted the postmortem examination on the body at 10:50 a.m. on January 25, 2015 noticed and recorded that the forehead wound was circular in shape and measured 1.5 centimeter in length and 0.9 centimeter in breadth, while the back wound was irregular in shape and it measured 2.3 centimeter by 2.5 centimeter in breadth and length. Full stop. It is elementary, that when a bullet, ordinarily, when a bullet first makes contact with a body or any hard object, the hole that it creates at the entry point is less than the hole that it creates at the exit point, comma, subject to being covered a bit of a distance through a dense medium in the interregnum. Full stop. Thus, comma, it would be evident from the observation of the doctor who conducted the postmortem at Nagpur Civil Hospital that the wound suffered was inflicted on the forehead and the bullet exited the parietal part of the cranium. Paragraph. Following the protest raised by the mother upon the findings of the postmortem being made known to her, comma, a second postmortem was conducted at the crematorium by personnel from that Negrim's full form. Full stop. Following such second postmortem, comma, the report by the relevant doctors indicated as follows, next line, open quote, bracket, capital T, bracket closed, then HE, the entry wound is on the frontal region of the head, situated 0.5 centimeter to the left of the midline, comma, the exit wound on the parietal region of the head, situated 2 centimeter to the right of the midline, and bruise on the left eye, full stop, close quote. Paragraph. Thus, it is evident that the doctors who conducted the second postmortem examination agreed with the finding of the doctor who had conducted the postmortem at the Nagpur Civil Hospital that the deceased had been shot on his forehead and the bullet exited the skull through the back of the head. Full stop. The two police personnel who had first discovered the in charge of the Patarkam outpost after he suffered the gunshot injury, did not report of anything untoward or having spotted anyone, full stop. A more senior official reached the spot immediately as he was staying in the nearby guest house, full stop. Photographs were taken immediately of how the body lay before the then still surviving officer was lifted and taken to the CHC, full stop. There appears to be no material to suggest any foul play or anything remiss about the place of occurrence, warranting any suspicion that the fatal injury could have been inflicted on the official by any other person. Paragraph. As to the mother's suggestion that since her son was right-handed, he would scarcely use his left hand to shoot himself, it does not appear that using the left hand to hold a gun next to one's forehead and pull the trigger would cause any great difficulty even to completely right-handed persons whose left hand may be as non-functional as possible. Full stop. It is not difficult to imagine a gun being lifted even by the lesser hand, being held to the forehead, and the trigger being pulled without any difficulty. Full stop. In the scenario when there is nothing else which stands out as an anomaly, it cannot be conjectured as to why the deceased used his left hand, as long as it is evident that there may not have been any other person at the place of occurrence or any trace of any person being present at the time of occurrence. Full stop. Paragraph. There is no doubt that the power of the mafia that runs the illegal coal business and the ancillary coke plants is wide and almost all pervasive. Full stop. Indeed, despite there being a prohibition on the mining of coal in this state, other than by adopting the scientific method and in accordance with law, by the National Green Tribunal, and such order being specifically endorsed by the Supreme Court by or about the year 2016, the illegal mining of coal continues to be rampant in the state. Full stop. For any person, even with impaired vision, the train of trucks, the train of overladen trucks carrying coal is all there to see on the state's national and state highways, but the administration, for reasons best known to it, turns a Nelson's eye to such activities. Repeated orders of this court over the last 18 months would reveal the frustration experienced because of the lack of action on the part of the administration. Full stop. It only appears that some form of action, over the last month or so may have been taken, but it appears to be only token action and not intended to arrest either the kingpins or the political supporters of the kingpins who are, obviously, on the gravy trail. Full stop. The malaise appears to go right to the top. Full stop. Paragraph. Returning to the matter at hand, in the light of what has been discovered by this court of the flourishing business in illegal mining, there is no doubt that the owners of the 32 trucks or the coal that such trucks contained wielded considerable authority or influence, and a part of the report is quite damning against the block development officer of the area. Full stop. Doubtless no action has been taken against such official or others who may have instructed him to act in the manner that he did. Full stop. While the mendacity of the entire coal business is plain to see, it is quite another to suggest that one or more of the persons involved with the trucks that had been apprehended may have been involved in killing the concerned official. Full stop. Paragraph. Ordinarily, even if a tailor-made investigation report is prepared, which the Indian judge has enough experience to discover, there are some anomalies and traces of contradiction. Full stop. At the highest in this case, what is evident from not only the case diary and the charge sheet, but also from the evidence that has come on record at the trial, is that it was the official himself who may have pulled the trigger on himself and not any other. Full stop. As to who drove such person to commit suicide and would be liable under section 306 of the Penal Code, is the object of the exercise being conducted at the trial. On a reading of the material produced, it does not appear that any person who has been intricately involved in the matter has been left out or protected, and comma, proving a charge under section 306 of the Penal Code is always a high task. Full stop. Paragraph. At the end of the day, comma, it cannot be lost sight of that a young police officer who may not have agreed with the manner in which the illegal coal mining activities were being continued, lost his life. Full stop. There can be nothing but sympathy for the family, comma, including the now deceased mother of the officer. Upon going through the material, it does not appear that the gunshot injury that killed the official was fired by any person other than the officer himself. Full stop. On the basis of the material, it cannot be said who may have put the officer to such desperation that he would take his life. Full stop. Doubtless, comma, the trial court will endeavor to unearth the truth in such regard. Paragraph. For the reasons aforesaid, comma, upon considering the matter afresh in the light of the directions issued by the Supreme Court, and upon being alive as to the extent of the authority available to a constitutional court, when any anomaly as to investigation is pointed out to it, comma, it does not appear that, particularly after 8 years from the incident, comma, any further investigation, fresh or de novo investigation is called for. Full stop. Paragraph. It is recorded that the matter has been gone into in great detail despite the original petitioner being no longer available. Full stop. Counsel originally engaged by the petitioner has been allowed to was allowed to participate in the proceedings. Full stop. Upon hearing both the state and counsel formally engaged by the original petitioner, comma, it does not appear that this is a fit case for any further or fresh investigation to be directed. Full stop. It is hoped that the compensation due on account of the untimely and unnatural death of the concerned officer has been paid in accordance with law to the person entitled thereto. Full stop. Paragraph. WP number so-and-so, which was revived pursuant to the Supreme Court order of May 8, 2023, comma, is disposed of. Full stop. There will be no onerous costs.
All right.
These are my motions. I'll give you all. I don't get this.
From the main list, item number 1.
Lordship, before your Lordship takes up, only one small observation. Lordship has just observed it's a high task to prove suicide. So maybe Lordship, maybe the defense can take advantage of that.
We've said that the doubtless will endeavor to
Independently, not in the executive order.
Yes. Just write one line. No observation here
Yes.
should prejudice or influence the trial court
Absolutely.
in any manner whatsoever, as the object of the present exercise was completely different.
Absolutely.
Full stop.
All right.
On the main list, item number 1.
May it please, Your Lordships.
Mr. Deb, before you start this, there are several judgments that we will give you, and we'll also draw your attention to several other provisions of the Evidence Act, which you and your other friend, Ms. Agarwal, is she Agarwal?
Lordships.
Should consider,
Lordships.
both as to 164 retraction of statement under of 164 under 313, section 30 of the Evidence Act, section 80 of the Evidence Act, what is the meaning of shall presume, all right? And there will be several cases that we will give to you, which you should consider, because all of them completely demolish everything that you say.
Lordship.
The law.
Much obliged, Lordship.
Yes.
Lordship, the instant matter, my lord, is the PIL also concerning coal, my lord.
Yes. And what is the focus of this one?
My lord, may kindly have the order of 7th of August.
Yes.
Here, my lord, we are mainly concerned with the complicity of the state, my lord, to maintain any records in the weighbridges.
Yes, affidavits have been filed.
Lordship, no, my lord.
678.
I'm appealing for 6.
06.
6 is Coal India, my lord.
Yes.
7 and 8, Lordship, are the private
So
respondents.
we've given you 3 weeks time. Why has no affidavit been filed?
I've been just giving instructions yesterday.
Very well, subject to the respondent number 6, paying costs assessed at rupees 10,000.
Lordship,
In course of this week, the time to file its affidavit is extended by a week from date. Full stop.
Even the state,
The deposit of costs will be the condition precedent for the affidavit being received. Paragraph. The 2 other respondents, now the other respondents should also file their affidavits, particularly the respondent numbers 7 and 8, within a week from date, with similar costs of rupees 10,000 each. Paragraph. It is high time that punitive steps were commenced by this court in the matters pertaining to the illegal mining of coal in the state and the complicity of officials all around in such matter, despite the prohibition in place from or about the year 2016, pursuant to orders of the National Green Tribunal and the Supreme Court. Full stop. The matter will appear a fortnight hence for further consideration.
Lordship, can I only pray, even the state was supposed to file an affidavit.
Very well.
Yes,
The state's affidavit should be filed within, the state's affidavit should also be filed within a week from date. By taking into account the orders that have been passed in the suo motu proceedings instituted by this court in March 2022 and the orders passed in the related matters pursuant to several interim reports being filed by Justice Kataki, who was engaged by this court to oversee the adherence to the order of prohibition and the disposal of the previously illegally mined coal. Full stop. Yes.
Obliged.
Or the next matter, please.
Finish.
Done. No, sir, get serious. We don't issue directions just for the fun.
that's true, Lordship. But do you-
That's all. Thank you.
Any mention for unlisted matter? Any mention for unlisted matter?
Unlisted.
From the main list, item number 1.
Lordship, may I please, Lordship? Lordship, I am appealing for the state of Manipur. In terms of a last order passed on 16 August 2023, time was granted to us to bring subsequent events to the passing of the impugn order on record. I have filed and drafted, I have supplied copy to the opposite party the day before yesterday at Imphal itself. Copies have been served to the party. Unfortunately, Lordship, the affidavit has been prepared in the format of the Manipur High Court.
That's all right.
I have filed it, if it can be called, Lordship. Yes.
Form does not matter, substance matters.
I have already filed it, is there in the court. I am ready for the...
This is the one.
I am deeply obliged, Lordship. I am ready for the final arguments, Lordship.
Yes.
Okay, please, Madam. Well, first of all, the additional affidavit which they have filed, well, it is,
Do you want an opportunity to deal with it?
Milord, it may be, there's nothing serious about it.
Nothing serious about it.
They just want to say that they have implemented the level single judge order, so therefore it may be allowed to continue.
That is childish.
This is what they have said, Milord.
That is childish. No. The order is wrong, everything done pursuant to it will go.
Right, Milord. They just want to say that let it continue. They have constituted the...
That is just creating some difficulty for the appeal court, nothing else.
Milord. Milord, may I take your lordship to the judgment, impugn judgment first?
We'll come to the judgment
Yes,
later. First, tell us, we are not going to allow you to waste time to read the judgment. You tell us what is the matter in issue.
Well, the matter is very simple, my lord. It is just whether the dissolution of the college management committee, my lord, dissolution is as per rule or not. My lord, I have got the rule, my lord.
We'll come to the rule. Why do you say that? Please,
Yes,
just
I'll say that.
let us understand the matter.
Yes, my lord. My lord, here I furnish the Manipur Education Court.
We'll look at the rules later. Tell us what is the prejudice that you suffer. Tell us what is the infraction that has been made. Then you come to the rules and the details.
My lord.
But let us get a feel of the matter.
My lord, the college, my lord, committee was constituted and then it has been dissolved, my lord, in gross violation of the provisions of the rules, my lord.
So college committee was constituted by whom?
By the government, Manipur government.
By the government.
Yes, my lord.
Very well. And it dissolved the committee
It was dissolved, my lord.
illegally.
Is the my lord, may I take your lordship to page number 61, my lord?
Yes.
That is the...
Yes, we must see the facts first before going into judgment or rules.
My lord, under clause 10 of section so and so,
Page?
page 61, my lord, A2. Shall I read, my lord? Under clause 10 of section...
Just a second, just. (61). This is a document dated order of 2nd March 2021.
My lord, my lord.
Passed by the director of university.
Yes, my lord.
So this college was under this university.
Yes, my lord.
What university is this?
My lord, it is a Birahari College, my lord. It is a body of non...
That is the name of your college.
Yes, my
What
lord.
is the name of the university?
My lord, it is Manipur University it is affiliated to Manipur University, my lord.
Manipur University.
Yes, my lord.
And Manipur University must have its own statute.
Yes, my lord, Manipur University, it is a central university now.
So it's been constituted under a statute passed by the government of Manipur?
And by the central
By the central government?
Central government, my lord.
Yes.
This committee was dissolved.
Clause 10 of section 4, granting it colleges of the state of Manipur, Manipur Education Code 1918 Department, the governing body of Naurem Birahari College, Chandrakulam, constituted with immediate for a period of 3 years. So 3-year term. Yes. And
My lord, then next page, my lord, it was dissolved. Next page.
Page 61. Page 62, dissolved. Order dated 29 September 21.
My lord, may I take your lordship to page?
Now the constitution is on 2nd of March
Yes, my lord.
and the dissolution is on 29th of September.
Yes, my lord.
And the first thing that is said is, unfortunately, during the last couple of years, that committee was not even there.
Sorry, my lord.
Look at point number 2 at page 62. Unfortunately, during the last couple of years,
Yes, my lord.
during the last couple of years, the concerned committee was not even there.
No, my lord. My lord, may I take your lordship to para 5, my lord?
Paragraph 5.
Yes. Now, therefore, after careful minor examination of all facts and circumstances arising out of the aforementioned situation, the Governor of Manipur is pleased to dissolve the governing body by invoking the provision provided under subsection 27D and concurrently withdraw and suspend the grant in aid provided to Naram Bihari College, Kundrakpam with immediate effect and until further orders. All orders issued, approved, conveyed to this in this regard is in respect of college.
Very good. Now, bring us to section 27.
Yes, ma'am.
Of what is this? What order is this? Section 27 of what?
Manipur Education Code.
Section 27D of Manipur Education Code,
Yes, ma'am.
1982.
Ma'am. Section 4, at page number 157, ma'am. Section 4, page 157, ma'am. Is there
Oh,
relevant?
subsection 27D.
My lord. Before that, my lord, may I take your lordship to section 2, my lord, page 157, 56. In these orders, unless the context otherwise requires.
Just a second, please.
My lord.
Give us some time.
My lord.
If you read it to yourself, you can do the matter at home, sir.
Sorry, my lord.
Page
156, madam. Chapter 4. Before 156, 157 is not numbered, madam.
Hundred and 54. Oh, it's like both sides of the book. Yes. General Principles Conditions, Code Section 4. Governing payment of granting. So this is the granting aid code.
Yes, madam. My lord.
Yes.
I want to draw your lordship kind attention at the section 2, my lord, which is the definition.
In
Your lordship,
the
the
Directorate of
government.
Education.
The government means the Directorate of Education, Government of Manipur.
Yes.
And the director means the Director of Education, Government of Manipur.
Yes.
Yes. Now I take your lordship to section 27, madam. Page number 166.
Now, this dissolution
My lord.
is not ordered coupled with temporary with a caretaker governing body. Grant may be suspended withdrawn any time if the tone, discipline, organizing instruction, answer, member of the governing body. So this is requires show cause 27.
My lord. And so called,
Requires show cause,
and the government means director. In both cases, they have
and in
put it.
particular, grants are liable to be withdrawn if ABC, the government reserves the right of dissolving. So ABC is grant to be and D is where grant is not suspended or withdrawn, but the governing body is replaced. But D is also governed by the first part,
Yes,
which means it has to be show cause and reasonable opportunity.
Yes, ma'am.
Can't be without that.
My lord.
In case of misuse of grant, I mean,
This is our grievance, my lord.
yes,
They said they have given it the so-called notice, but that is after, my lord. This is like beating the horse after it is dead,
very,
my lord.
where is the,
My lord.
actually the,
Well, at page 62,
actually the problem is
Hello.
bolting the stable door after the horse has fled.
Yes.
Nothing to do with the death of the horse.
sorry, my lord. Well, at page 63, my lord, para 6.
Page
63, para 6 of the dissolution order. They said this is the so-called notice, which the so-called notice has to be given before the issuance of the dissolution order, but they have done it with the dissolution order.
yes,
And my lord, also it has been issued by the governor. The deputy secretary has signed it.
the order has been by deputy secretary.
My lord, it has to be director. This is the only case, my lord.
By the government.
This is the only case. Now, may I take your lordship to the impugned judgment, my lord?
Yes, yes.
My lord, may I take your lordship to the para 30, page number 22.
Impugned judgment is part of this file.
Yes, my lord.
At the beginning or at the end?
Both, my lord. Here in the beginning it is there. Page number 22, my lord. Para 30, my lord.
Arey baap, it's a dark path. Moved either.
Shall I read, my lord? Here the learned single has justified the issuance of
Yes, sir, yes.
My lord, this has been contradicted by the learned single judge himself, my lord, in para 39.
That's it. Oh. You know, you have to learn how to make the order look fat.
Para 39 has contradicted himself. Finding it para 30 has been contradicted in para number. In 30 he says it is justified. There is no wrong.
Rubbish. Total rubbish. Not one word of it can be sustained.
Please, Lordship. May I, Lordship? I will try my best, Lordship, to support the judgment. I can understand, Lordship.
You are the Advocate General, sir.
Lordship.
Are you the Advocate General?
I am the legal advisor to the Honorable Chief Minister and a Special State Counsel.
Well, whatever you may be, those don't impress us.
No,
For the dignity of the state, we would have expected the state to come and say, sorry, we will correct ourselves. Because you'll have hell to pay for once you argue and you lose.
Lordship, there is one aspect I wanted to clarify. The rest I leave it to my Lordship. I will not go in.
Please come to the... What is your name, sir?
It's Rary Mangsat Alam, Lordship.
Sorry?
Rary Mangsat Alam, Mangsatabam. Rary Mangsat Alam.
I'm sorry, we mispronounced that.
There
Sorry.
is a tongue twister.
No, it's not a tongue twister. It's that it's unfortunate that we all living in different parts of the country are not acquainted with each other's, kind of names. I find some names over here also to be difficult to pronounce, as I'm sure people from here will find
Lordship,
Bengali names difficult to pronounce.
During my school time, I was called M.R. Singh. It was much easier, Lordship, but I just changed it. It was too long.
Please come to section 27, subsection 27. Now, I will read it for you.
Lordship, just before going to section 27, I just wanted to show one, the beginning of this. This is actually a provision flowing out from section 4.
Are you aware, sir, of the judgment in the case of the Chief Election Commissioner?
Chief Election Commissioner,
Supreme Court judgment. What was his name? Mohinder Singh Gill.
Mohinder Singh Gill. I am aware of that. I will be referring
When they have quoted
Yes.
Justice Vivian Bose in paragraph 8,
Yes, Lord.
where the last line is old wine in new bottle.
Yes, Lordship.
What is the proposition?
Lordship, the propositions of Mohinder Singh Gill and others have crystallized into their effect, their Lordship, the question of principle of natural justice, which we call
No.
reasonable and
Nothing like that.
fair play.
Mohinder Singh Gill is nothing of that sort. Mohinder Singh Gill's principle is that when a reason has been indicated by an authority for taking a decision, no other reasons will be allowed to be substituted or added than what is indicated in the decision itself. In your order of revocation, let's call it revocation, dissolution, whatever it is, you have simply relied on 27D, nothing else. So your order will stand or fall on the anvil of 27D, not on Constitution, not on 4, not on the Criminal Procedure Code or any other thing that you are able to cite. It has to stand or fall only on 27D. Now please come to 27. Grant may be suspended or withdrawn anytime by the government if the tool, discipline, organizing instructions, or any of the conditions laid down in these rules. Grants are also liable to be withdrawn if any member of the governing body or college takes part in any objectionable, anti-political, commercial, or any other after giving the governing body a show cause notice and reasonable opportunity to explain their position. So there is a cart, there is a horse which comes before the cart. The horse is show cause. After that, there is a handle which is the response to the show cause. Then comes the cart, which is your decision whether to withdraw or suspend or otherwise. So where has the horse gone over here? Here, the cart is leading the horse.
I understand, Lord. I may have to justify that issue, Lord, because I knew this is a question which will come up. So I will go into that issue mainly. Lord, in this college started off as a private college and it was given grants in it.
Sir,
now
we accepted that there is complete anarchy in that college.
Not only anarchy.
We accept it.
Lordship, it's
We
not only anarchy.
accept that there is sedition going in that college.
Not only that, Lordship. The question was of financial misbehaving, illegal appointments, the manner in which salary was not paid.
We've seen all of that.
Now, if that is a situation, whether it is a mandatory duty of the
Absolutely mandatory. Absolutely mandatory.
To put a stop to it immediately, to put a stop with it, or we should have continue with that, because an FIR has been lost also, Lord.
May have been.
Now the situation is that, Lordship, there is a provision besides this in section 28 following the 29, which talks about a non-obstante clause, Lord.
Yes.
This non-obstante clause says that all other provision of section 27 will also.
Where is that? Where is that?
The 20 after 27, 29.
Notwithstanding
anything contained in this rule, any other person, this will have an overriding effect.
Yes.
The government reserves
itself the right
to withdraw any grant at any time entirely at its discretion, and when the government is not satisfied with the functioning of. If it is a non-obstacle clause, Lordship, whether it will have an overriding effect on the
I did
other.
not invoke that.
Lordship, this section 27 is in a situation where a normal situation comes in, where there is the issue of the mismanagement or some other issues on a lesser degree.
Very well.
But if the state government comes to a position where, Lordship, I can understand. I believe Lordship is not able to, I'm not able to impress upon my Lord, but I will try as a representative of the
If you
state
had been
government.
a private person, we would have allowed a bit. You are the state.
Yes, Lordship, the intention of the state, Lordship, the intention of the state has always been right, Lordship. We have never sided with any side. But the difficulty is that, Lordship, it may be up to the petitioner today, how many litigations was going on in the High Court when this matter was there, Lordship. So many cases, one after another, filed by both the sides. The government is dragged into not able to function, Lordship, in this
The
regard.
question will be,
Lordship.
how many scientists were involved in preparing Chandrayaan? That will be a more relevant question.
Lordship, the basic question is that I agree, Lordship. We did not give a decision hearing, but it was given a post-decision hearing.
There are two ways in which this can be resolved, because we will go a bit more. We will find malice in fact over here. complete malafidis, you can make a statement that the original board will come, that they will be given a reasonable time, 3 weeks or 4 weeks to show cause, and that you'll deal with it. Until then, control the manner in which funds are given so that the college can run, the grant continues, but you can put some checks and balance. That much will continue since you're talking of financial irregularity.
Total, Lord.
But thereafter, if you find good reasons, throw them out. Sir, over here, what hits you first is that your dissolution notice refers to 2 years, whereas the governing body you appointed only 5 months back. So this governing body, whose life is 5 years, is surely not responsible for the irregularities that, according to you, have continued for 2 years. If you were aware of the irregularities for 2 years, why did you constitute the body in March itself? You should have said that, no, we will not constitute any body, we will put people, custodians or something, or we refuse to give grant.
Can I clarify on that, Lordship?
Yes.
There is a point.
Please.
The litigation started, Lordship, one after another, contempt notice, everybody was in the High Court, Lordship, nothing was working. Internal fight, physical fight happens, Lordship, police was involved in the college. No, I'm just coming to
Have
that,
you seen all this? Have you seen all this?
Yes, Lordship. Now what happens?
What color is this?
Lordship.
It's not by the breeze which is blowing.
Now what happened, Lordship, was that in that situation, it became very difficult at that point of time to streamline the college in such a manner that both the warring factions and others, Lordship, the college functions, Lordship. Because the students was also suffering.
But
The students was also suffering.
We will give you a chance, sir.
Lordship,
You can make that statement, for which we will give you till Monday, or
Lordship.
we will,
I will seek instruction,
but
Lordship.
we will under no circumstances,
Lordship.
even if there is an earthquake or a natural calamity, under no circumstances shall we adjourn the matter on Monday.
Lordship, we will not. I will not seek. I will not seek any date. Lordship, I was handed the file 3 days back. Lordship, still I was ready today. Lordship,
Thank you.
I prepared the affidavit of my file.
And sir, we must say, at the end of the day, you have conducted the matter with the dignity that a government
I am deeply obliged.
should participate in.
Malad, can it be on Tuesday, Malad?
Just indicate something. We are not going to say anything right now. We'll give them a chance to rectify. If they don't rectify, we'll record it. Don't worry.
On Tuesday, Malad, because Monday.
No, sir. No, sir. Monday.
Malad, I'll be out station, Malad, on Monday.
Even if you're out, participate on the virtual mode.
Yes, Malad.
Oh, then we can participate in virtual mode. Then it's very easy for us.
Yes.
Malad,
Virtual mode is available all the time.
We'll participate. in
Malad,
virtual.
may I point out only one thing? They have admitted that it was an illegal order in their counter affidavit. Page number 97. Page 97.
If he's not going into
we
force,
will get them.
Illegality. Page 97.
Prima facie, upon hearing both sides, upon hearing both the appellants and the state, it does not appear that the impugned judgment and order can be sustained, or there can be any justification, there could have been any justification for the impugned dissolution notice of September 29, 2021 having been issued. Full stop. At any rate, the relevant notice of dissolution appears to be contrary to the provision of the Granting Code that it quotes. Full stop. Paragraph. In such a scenario, the state of Manipur is afforded an opportunity to take remedial measures as suggested and which need not be recorded. Full stop. However, considering the gravity of the matter and the colossal illegality in the issuance of the relevant notice, comma, the time afforded to the state is till Monday's date, full stop. The matter will appear on such day, and no prayer for adjournment will be entertained in any circumstances, comma, any circumstances, full stop. In the event the state of Manipur takes corrective or remedial measures as may be found appropriate, comma, the matter will be allowed to rest at such stage without the appeal being required to be formally decided, full stop. If otherwise, comma, law will follow its own course, full stop, paragraph. Since the matter has been transferred to this court by the Supreme Court, comma, it is made clear that learned lawyers may avail of the virtual mode of appearance, full stop. However, comma, any excuse of lack of connectivity, comma, particularly on the part of the state, comma, will be completely disbelieved. So we've cut off your excuse before.
Lordship. I'm for one, Lordship.
Because we'll have to write bad things, which we don't want to write about the government.
Lordship, this order has been superseded by other orders also.
May have been. If the order is bad, nothing can be done.
Item number 3.
Order the copy.
It will be the first matter on Monday. It will be the first matter on Monday.
Oh.
You will get a copy of this order from the net by this afternoon.
Okay. I'm deeply obliged,
You
Lord.
don't have to rely on anybody.
Oh, no, I'm deeply obliged.
Item
Give
number
this as the first order.
Well, my only prayer was that can it be on Tuesday, my lord.
Sorry?
My only prayer was that can it be taken up on Tuesday, my lord. Yes. Only that person.
Tuesday, you will be in difficulty. Because I will not be there for some time.
Sorry, my lord. Then my somebody will be there. Hello, guys.
Yes. Have you got the reports?
I just received a copy.
You just received a copy.
Your Lordship.
A report has been filed by the state. Since the petitioners have been furnished a copy of such report in court today, comma, let the matter come up a fortnight hence for further consideration.
My lord, the 50 meters restriction and all has also been
Very good. We understand. We are happy with the look of it. There's a couple of pages I turned.
Yes.
There's something happening. And technical personnel are also involved in this. So
Monitoring committee.
very good. They are better than us. We have no expertise. So if they together, all of them decide what would be a course of action, we'll be happy with it. We'll yield to their expertise. We don't have the requisite expertise. Look into it.
Yes.
If there are any anomalies, if you have any suggestions, constructive suggestions,
Your Lordship.
not to stop someone's work, or constructive suggestions.
Your Lordship.
Yes. Copies of the report may also be obtained by any of the other parties from advocate for the state.
Yes, ma'am.
Obliged.
Last matter.
Sorry. Hey, this is part of that matter. My notes are here.
Thank you. Single bench.
Yes. When will you fix it? Next week?
It's there.
The causal shows is on leave. Causal shows is on leave. Yes. Yes.
We are ready to take?
Yes, we are all ready, but Miss District Council is again not here, my lords.
We can do with his absence.
Lordship.
District Council has no role. And no one is seeking an adjournment either.
Well,
District Council should be a disinterested person over here.
But in fact, they filed an affidavit reiterating the position that Rani was there in there.
and your lordships would recollect there's an order passed that there was some anomaly. We were
Yes,
permitted to file
yes.
affidavits. We filed the affidavits.
But then we are dealing with outstation counsel over here. He is not available here.
No, my lords, I'll be here. I'll be here. As a matter of fact, it would fallen from your lordships that I should be here or
Yes, she is not asking for time today.
May it please, Your Lordship? Your Lordship, my senior, Mr. Vijay Kanta, was ready for hearing, Your Lordship. He was going to do through VC, but then he had to catch a flight, Your Lordship, from Agartala, so he had to go offline, Your Lordship. That's why, Your Lordship, Your Lordship, this matter can come up next week, Your Lordship.
We'll try again on Tuesday. Tuesday.
Much obliged, Your Lordship.
There is very little that the court can do when parties do not cooperate in the hearing. Full stop. This matter has been adjourned on several occasions on frivolous pretexts, and despite the entreaties by the court and the present date being fixed upon consent of all parties, the district council is not represented on the ground that council had to take a flight. Full stop. Such conduct is not appreciated. Full stop. The matter will appear on so-and-so and will be proceeded with, irrespective of who may find it inconvenient to be present.